SJC-12151, Commonwealth v. Kyle Tuschall.
Thank you. Good morning, Mr. Mass.
Good morning, Mr. Chief Justice, and good morning, Justices of the Court. My name is Assistant District Attorney Randall Moss, arguing this case on behalf of the Commonwealth. The judge erred in allowing the motion to suppress. The Watertown detectives were justified in entering the defendant's apartment based on the emergency aid exception to the warrant requirement.
Both times?
That's correct, Your Honor, yes. So with respect to the first entry by the Watertown detectives...
Who are they trying to aid?
Well, there were two justifications for the entry. The first one was to prevent the continued release of harmful fumes coming from the apartment, and so it would have been to aid the surrounding residents of the apartment. And the second justification was to look for the female tenant of the apartment who had been reported missing, or excuse me, there was some indication that she was missing that morning.
Well, she was listed as a tenant. They just didn't know whether she was home or not, right?
Well, with respect to the search for the missing tenant, the police arrived at the apartment on the morning of June 13th. They spoke with the upstairs tenant, and the upstairs tenant informed the detectives that she had not seen the female tenant that morning. She usually sees the female tenant and the male tenant leave together from their apartment, and at 8:15 she had seen the male tenant leave, but she had not seen the female tenant with him. So based on that information and based on the fact that they could not locate her when they knocked on the door.
Was there some evidence, though, that somebody said that, or maybe she said that she hadn't seen the female tenant come back with him the day before, something like that?
Well, the upstairs tenant, actually, she had spent the evening at a separate apartment because of the harmful fumes that were emanating from the downstairs apartment. So she wasn't there. What she did say to the police officers, however, was that she usually sees the female and male tenant leave the apartment together. She saw the male tenant leave at 8:15, but the female tenant was not with her.
Say anything about who came the night before?
No.
Okay. I thought you did.
But the other emergency that was unfolding at the same time as this information about the female tenant came to the police officers was this strong and harmful chemical odor that was emanating from the downstairs apartment. So the upstairs neighbor reported to the police the day before that this chemical smell was so powerful that it gave her headaches and that it appeared to make her dog feel ill. When the police officers arrived the next day, and this is when the neighbor gave them additional information about the downstairs tenant, the neighbor informed them that the smell was so strong that she had actually spent the night before at a neighbor's apartment. And the police officers' firsthand observations confirmed what the neighbor said about the magnitude of this odor.
Is there any objective sense of, is an immediate risk of an explosion or something like that, objectively looking at the information the police had?
Well, I think based on the fact that it's a strong chemical odor, the police officers described it as a smell similar to nail polish. I mean, certainly there is a danger of inhalation injuries, a danger to others.
So when anybody goes walking by a nail salon, you can just go and do it because there's a strong chemical odor of nail polish?
Your Honor, it's clear here that this it's not just an odor akin to that at a nail salon.
Didn't the judge say something about, since the next officer who came had some experience here, that there is a distinction between this level of odor and what would signify an imminent explosion?
I don't recall
Did I make this up?
I don't recall the judge making a finding about the
night.
level of odor that's necessary.
But didn't he talk about an active cook?
Yes, the rule of law that the judge applied here in distilling the out-of-state case law on meth labs was that a warrantless entry of a residence suspected to harbor a meth lab is not justified unless police have evidence of an active cook or that the meth lab is actively operational. This is also the rule that's proposed by the defendant in the defendant's brief. However, it's not the rule that this court should adopt. It's flawed in a number of respects. First of all, the motion judge assumes that the only danger posed by a meth lab is the risk of explosion, but as the facts of this case demonstrate, based on the officer's testimony and upstairs neighbor's testimony, and as the case law cited by the judge himself attests, there's a separate hazard associated with meth labs as well, and that is the danger of inhaling noxious chemical fumes. So that's,
But we're talking about an exception to the warrant requirement. There's nothing that would preclude securing the scene, getting a warrant, and coming back, correct? There's plenty of probable cause.
there's probable cause, Your Honor, but there is an emergency situation that the police needed to respond to in a limited period of time. There's a chemical...
To it a day later.
Well, Your Honor, if a close examination of the timeline in this case shows that the danger that was posed by the smell emanating from this apartment actually escalated over time. So the first call came in to the Watertown Police on Wednesday. There, the upstairs neighbor said that she smelled the smell like drugs coming from downstairs. So it was general and it wasn't particularly urgent. The police officer called the upstairs neighbor the next day. There was more information. Again, the upstairs neighbor said that it was so strong it gave her headaches and her dog felt out of it. When the police officers showed up to the apartment the next day, the situation was even more perilous. The upstairs neighbor had said that the smell was so powerful now that she had to spend the previous evening away from the apartment, and the police officers' firsthand observations confirmed what the neighbor had smelled. So standing next to an air conditioner that was emitting these fumes, the officers said that they could smell a nauseating chemical odor, and that when they went into the common basement of this apartment and had just that limited exposure, being under the immediate area where this chemical odor was coming from, the police officers testified that, or Detective Lewis testified that his eyes started watering and his throat felt scratchy.
That's true, but, I mean, that provides probable cause for a warrant, but where is the need to just go in twice to the same apartment without a warrant?
Well, the first entry was justified, again, to prevent
Come to the
the
aid of a
continued
person
release.
that you weren't sure was there.
Exactly, and to prevent the continued release of toxic fumes. The second entry was justified because, based on the testimony of Detective Gutwell, who was the Framingham detective who's assigned to the DEA, who the Watertown detectives called, Detective Gutwell testified that even though they were certain there was a meth lab inside, it was necessary to go inside because some of the chemicals that are used to produce meth may reactivate even in an inactive setup. And
How
so,
long did it take to get that specialized expertise on site?
I'm not sure they call them around 11 o'clock. I don't think the judge made a finding about what time.
I mean, if it was long enough to do that, why couldn't you get a warrant?
Well, again, the police officers, before they called Detective Gutwell, they were responding to an emergency situation
I
where
meant
you
for the
had...
second time, if not the first time. Why couldn't you get a warrant between the first and the second time?
Well,
If there's time to call somebody else to come in and take a look, why isn't there time to get a warrant?
in the training and experience of Detective Gutwell, who works with the DEA, and on the clandestine lab team and is assigned to investigate clandestine labs, his testimony was that the chemicals used to produce meth could reactivate and cause explosions. And so he was dealing with what he thought was an emergency situation, which he reasonably thought was an emergency situation. The police officers didn't necessarily have time to go out and get a warrant. And to your question, Justice Graziano, that is the second flaw in the rule applied by the judge. By ruling that the officers may enter a meth lab only where they believe that there's an active cook going on, he discounts basically what Detective Gutwell testified to, which is the danger of inactive labs. And again, Detective Gutwell testified that chemical residue inside even an inactive meth lab can reactivate and cause a fire. And the final reason that rule that's applied by the judge is flawed is that it's unworkable. You can apply it to the circumstances here, where the police show up, they smell a strong chemical odor that they could suspect was related to a meth lab, but how could they know whether a meth lab was operating without seeing the chemicals and equipment?
But I gather from the judge's findings that they didn't say the smell is consistent with a meth lab, that we think there's a meth lab when they first went in.
Detective Lewis was he and Detective McNeil of the Watertown police officers, they were the first police officers who went in. Detective Lewis works with the Middlesex Suburban Drug Task Force. He has training and experience with respect to methamphetamine. The judge finds in his order that the detective, based on his training experience, could have reasonably suspected that the smell that he smelled was linked to a meth lab. However, to answer your question, there's no specific line of testimony in which he says, I identified this chemical to be such and such, which I knew was part of the meth lab, the process of manufacturing methamphetamine.
So, I mean, the question, I guess, is how do we define an emergency? Is an emergency simply that there is a nauseating smell, or is the emergency the risk of an explosion? The risk of an imminent explosion?
I think the two are related when you have a strong chemical odor, and I think the rule that the court should apply in this case is where, in circumstances such as this, where the police respond to a residence and they smell a strong and harmful chemical odor of the magnitude described here in the motion to suppress, where just brief exposure to the chemical, for example, can cause headaches or cause eyes to water or throats to be scratchy, and other corroborating factors. So here, the police officers observed several air conditioning units running in this bottom apartment, along with the fact that the windows appeared to be sealed.
It was summertime, wasn't it?
That's correct, Your Honor, yes. But this is something.
Closing the doors and keep leaving the AC on?
It's notable that this is something that caught the attention of the upstairs neighbor as well. And what's remarkable is that there were, in the testimony of Detective Lewis, several air conditioners running.
And was there any evidence as to how long they had been living there and how long the smell had been coming from there?
The police officers responded on Friday morning. The first call came in, which again was just of a general nature. There was a smell like drugs coming from the downstairs apartment. That came in on Wednesday.
Came in on Wednesday. And did they indicate how long? Did they say we've been smelling this for a long time, or we just this morning began to smell it?
There wasn't an indication either way, Your Honor.
So we don't know how long that smell's been there. And we don't know how long that neighbor's been there.
That's correct, Your Honor. But given that the call came in on Wednesday, and then in subsequent conversations, and then when the police officers arrived at the scene, there was, as I describe, an escalating situation at this apartment.
Is it your view that at least the first entry you would justify as community caretaking? Or is it that you say, no, there was, because of the smell and the other things of the windows being taped and closed and the air conditioners, and I think the upstairs neighbor said something about there was a lot of light or something
That's
like
correct,
that, that there was probable cause that there was a meth lab?
To argue that there was probable cause, that would be a harder case for the Commonwealth under the emergency aid exception to the warrant requirement.
It's
in
community
Massachusetts.
caretaking, emergency aid kind of thing.
Yes,
Okay.
they're based on what the detectives smelled and the upstairs neighbors smelled, and based on the other observations, there were objectively reasonable grounds to believe that an emergency existed. Add to that the situation that unfolded on Friday morning, where the female tenant hadn't been seen some time, and you have two emergency situations unfolding simultaneously that the police officers needed to respond to.
Well, so you have Wednesday, the call comes in.
Yes.
Thursday, he calls her and says, can you give me more information? Friday morning, they come back. At what time?
It was after 8:15 and before 11 o'clock. Those are the
Okay.
two bookends we have.
And the search occurred at what time?
Later in the afternoon, after Detective Gutwell had made his entry into the apartment.
So 8 a.m., they begin this inquiry, and then the search is in the late afternoon?
It would have been after 8:15. The search, excuse me, Your Honor?
All right. So 8:15 is they go to the basement on Friday.
Well, it was after 8:15, sometime after 8:15. we know
Okay,
that.
but that morning,
Certainly, yes.
and then the actual so-called emergency search occurs about what time?
It's not clear exactly what time, but it's sometime between 8:15 and 11 o'clock. The first search takes place, shortly before 11 o'clock, it's fair to say, given that after they conducted that search, they then called Detective Gutwell, who arrived at the scene sometime later.
So the one that happened second happened when, at 2, or in the afternoon sometime?
I'm not sure that there are findings of fact as to exactly when this,
Evidence about this?
the second search?
Yep.
Detective Gutwell did testify, yes.
No, but was there evidence as to what time it took place?
I don't believe there's testimony about the precise time at which
Well, was it in the afternoon, or was it in the morning, or what?
Detective Gutwell, when I was answering Chief Justice Gant's question with respect to the search, I meant the search warrant. So the search warrant would have been executed sometime later in the
search warrants
afternoon.
in the afternoon.
So after Detective Gutwell went into the apartment, made sure that there were no chemicals that could reactivate, cause a fire. But I don't believe the judge makes precise finding as to when Detective Gutwell's search took place. It would have been sometime after 11 o'clock when he was called to the scene.
Okay, thank you.
My time has expired. Thank you, Your Honor.
Ms. LeClaire, good morning.
May it please the court, Jessica LeClaire for Kyle Tuschall. The emergency exception requires a true emergency. It doesn't allow officers to make a warrantless entry to rule out the vague possibility of an emergency or to allay their subjective fear that there's something suspicious going on. The facts here don't support an objectively reasonable belief that the officers were confronted with a true emergency. First of all, the officers don't identify the smell coming from the apartment. They don't have any knowledge as to what the smell is. Second, there's no evidence that it's associated with methamphetamine or that they have any knowledge or belief that it's associated with methamphetamine.
When's the first time someone utters the words meth lab in this case?
In the testimony, Detective Lewis says that after he goes in to locate the missing tenant, he sees items he believes are consistent with a meth lab. That's the first articulation.
Before, when they're snooping around in the basement, nobody says meth lab.
That's right.
And you would obviously concede, well, maybe you won't, but you would obviously concede that if the police had smelled, natural gas coming out of an apartment, and they can go in. If they had information that this was a meth lab operating with inherent dangers to explode, they could go in.
Well, according to the overwhelming weight of the authority from other jurisdictions, which is what the judge relies on here, is that not only does there have to be a smell associated with the manufacture of meth, but the officers have to have knowledge that that smell is associated with meth, and there need to be indicators that the meth lab is operating. The pure aroma doesn't in and of itself support an entry under the emergency exception.
What would be, let's just say there is this undefined, extremely noxious smell such that the upstairs neighbor for 2 nights running isn't able, she has to move out. And so she calls the police. And you say it's not an immediate emergency. So they seek a warrant, and what do they ask for?
Well, first of all, I think that before they do that, they need to call the fire department, call an expert, see if this smell is dangerous, canvass the neighbors. Are you smelling this smell? How this court in the Commonwealth v. Overmeyer recognized the subjectivity of smell. And so we have a smell emanating from the air conditioner. Is it somebody just had their floors polyurethaned? Is the neighbor susceptible to particular aromas? This smell has apparently been emanating for 2 days.
But they went in there for just 2 minutes or so, then left and did exactly that, didn't they?
That's
called
what
the
they do
Watertown police,
after.
and they called and got an expert. So they were in there 2 minutes and smelled something, went in there 2 minutes and did exactly what you say they should have done.
Right. Well, the officers, before they go in, they don't know if this smell poses a danger. They don't know if it poses what matters under the emergency exception, a requirement, an imminent danger. They have time, they take the time to call the landlord. They take the time to wait for the landlord's son to come to the residence. During that time, perhaps they could have called, as the judge notes, could have called an expert to identify, what is this smell? Is it really harmful? And is it imminently harmful? And if you look at I want to point out what my brother stated, that there's evidence, there's no finding that this smell was escalating in danger between conditions on June 11th and 2 days later on June 13th.
But do you concede that if the entry to look for Molly was okay, that that was a legitimate emergency aid justification, that what the police saw in the house after they got in there with this legal entry gave them probable cause, so that the only issue would be whether there was any exigency in failing to get a warrant?
Probable cause, I think that, to answer your question, I think we don't concede that entry for Molly J was appropriate, but if they
asking if you
do.
lose on that issue.
If we lose on that issue, the officers go in, Detective Lewis testifies, he sees an item he believes is used for smoking meth. I think that would provide probable cause to believe that there's a possessory offense going on here. Does it provide probable cause to make a warrantless entry because there might be an explosive meth lab? Absolutely, we do not concede that issue, because the only evidence here in the record is Detective Lewis says, I saw items consistent with a meth lab. He doesn't go into specifics as to what those are. There's vague testimony on that point, and the judge doesn't make any findings that there were chemicals in the residence that Detective Lewis saw, chemicals that are consistent with a meth lab. So we only have his viewing of a device that he describes as being used to smoke methamphetamine, his belief that it's used to smoke, and a white substance. That's what they see in the apartment, and that's the only evidence of what they see in the apartment during that first entry. So I would also point out, I mean,
Do you agree that if there were an imminent risk of explosion, whatever the source, that would be just cause for entry?
an imminent risk, if they had reason to believe that this place was about to blow, I think that would provide, that would satisfy the emergency exception. And I think there are two cases in Massachusetts, excuse me?
I wanted to follow up on Justice Gaziano's question about natural gas, because I think that maybe is that sort of the smell that could be consistent with an imminent danger of explosion, even if you don't know anything more than that?
Well, the case law on the question of natural gas, there is a case law, Commonwealth v. Cantelli, where there's a smell of natural gas, and actually the landlord and the realty agency go through the steps of getting a civil summons to go into that apartment. So I think, generally speaking, if we smell gas emanating from an apartment, that might indicate an explosive situation. But I think in that situation, the question is, what do the officers know? Because in this, the cases from other jurisdictions repeatedly affirm that the officers have to have knowledge of the possibility of an explosion. And there have to be indicators that suggest that their fear of an explosion is a reasonable fear. So generally speaking, with a potential gas explosion, I think that would satisfy the emergency exception. Now, what the Commonwealth's argument, what they do in Commonwealth v. DiGeronimo, the appeals court said, quote, an exigency cannot rest on an after-the-fact discovery of a justification that never occurred to nor was mentioned by police, end quote. And that's what we have here. The Commonwealth, the officers don't articulate any concern about a meth lab prior to their entry. And the Commonwealth articulates the question presented as whether officers who have a reasonable belief that there is a meth lab on the premises can make a warrantless entry. But what we don't have here is a reasonable belief that there's a meth lab on the premises.
Well, you can't, can you really separate these two issues, though, the community caretaker and the smell issue? Or is it the synergistic effect of the two ends up constituting an emergency? So they've got the issue, they're looking for, and they're knocking on the door, please, please, nobody answers, and findings of fact seem to me to support that that the smell is escalating. So if you don't compartmentalize those two, but look at the two together, does it constitute, between community caretaking and emergency, constitutional justification?
Well, there's no reason to believe there's anyone actually home. So I don't think that the fact that no one answers the door advances the theory that this presents an emergency. In fact, the evidence is this person usually leaves in the morning with her boyfriend and hasn't been seen at the residence. The facts show that the officers arrive late morning, and then the search, Detective Gutwell enters at 11 o'clock. So the claimed missing person is only missing or whereabouts unknown for a very short period of time. So that together doesn't add to create an emergency here. And what I think the argument, to restate the Commonwealth's argument, I think what they're saying is we have a very bad smell. We have a bad smell. We know meth labs are dangerous. I think there's a huge evidentiary gap between those two propositions. The Commonwealth had the burden to present evidence that connected those two things to justify a warrantless entry into a home. The sacred, the Fourth Amendment in Article 14 provide great protection to that. And the emergency exception is subject to strict constitutional limits. So the motion judge here was correct.
Do you share Judge Billings' view that it must be an active cook?
The way that yes, I agree with his reading of the case law from other jurisdictions. What those cases stand for is that the possible presence of a meth lab doesn't in and of itself, by itself, create an exigency. It's the active processing that's going on in the lab that creates the emergency. Because if we have a reason to believe there's a meth lab, the officers can go and get a search warrant. And in the case I cite, in the First Circuit case I cite in my brief, which I miscited the case, it's United States v. Drake, and it's 673 F. 2nd 15, not F. 3rd. The officers follow this.
They're too young to remember F. 2nd.
I apologize for the mistake, but in that case, these very experienced DEA agents and chemists follow this individual around, and he's clearly prepared. It seems clear to them that he's preparing to manufacture meth. They get a search warrant before they enter.
We need not adopt the active cook distinction. It is suffice to say that the judge below didn't hear evidence in whatever form that there was an emergency.
Yes, Your Honor. Yes, I would agree that even if the standard is simply a reasonable belief there's a meth lab present, that standard wasn't satisfied here.
So what should the police have done here? They should have gotten someone to identify the smell as a meth lab smell and then gotten a warrant?
Well, I think they could have called the fire department or
Somebody
the
to
gas
tell them.
company. I'm sorry?
Somebody to tell them it was associated with a meth lab.
Right,
I'm not opposed to polyurethaning your floors.
They could have canvassed other people in the unit. They could have made a greater effort to find the two people who lived in that apartment. They knew there were two people there. The conditions seemed to be no different than 2 days earlier. They had time to wait for the landlord, so during that period of time, there were 2 officers present. They could have been taking more steps. But I also want to point out what might not be so obvious is we still don't know what that smell was. There's no evidence in the record that it was anything dangerous or imminently harmful or associated with a meth lab. That's insinuated in the Commonwealth's brief and in their argument, but there's no findings to that effect and no evidence of that. So
you're saying that at some point they could have gotten a search warrant. I guess what I'm saying is, when was that?
well, I don't agree that they would have been able to get a search warrant before they entered. There would have had to be more investigation before a search warrant issued. Perhaps they could have put interviewed the residents gone to greater lengths to identify what the possible source of that smell was, established surveillance in the area. None of the indicators known to them suggested this was an imminently dangerous situation.
No, but you wouldn't need imminently dangerous situation in order to get a search warrant, right?
Correct, correct. But you need to have some connection between the smell and an illicit substance. And we don't have that connection in the evidentiary record here prior to their entry.
Right.
Okay,
Thank you.